Okay, good evening, everyone. Welcome to this very interesting event that I'm looking forward to myself. I'm Dr. Philip Bear, one of the two co-directors of the Center for Medical Ethics and Law. My other co-director is taking a break this evening, Mr. Terry Kahn. And I'm sure you're all here not to listen to us, but to listen to Mr. James Badenoch. Again, I suspect most of you by now know him and know him very well, but allow me to just briefly give you a little bit of his CV. And James let me use this one, because this is a 3-page one and I have to summarize that. Mr. James Badenoch, QC, took SIP in 1989 and was lead counsel for what everyone here is waiting to listen to, the successful plaintiff in the Montgomery case. He has specialized in this area for over 35 years and has appeared in a succession of major cases in the House of Lords, in the UK Supreme Court, in the Privy Council, the GMC, the GDC. He's also appeared in Hong Kong's High Court and Hong Kong's Court of Final Appeal. He has also been Deputy High Court Judge, a Recorder of the Crown Court, President of the Mental Health Review Tribunal. He's a Fellow of the Royal Society of Medicine, and I can go on and read the second page, but I won't do that. I won't do that. I'm sure you're all here to listen to what he's going to say about the future of Bolam. But just to let him know what has happened since his visit last year when he came to talk to us about Montgomery is there has been a lot of discussions. Doctors are quivering and are worried. And the Medical Council has actually published a 4-page article as a result of Montgomery. And it's distilled into this amendment or revision in the book on professional conduct or misconduct. The explanation should be balanced and sufficient to enable the patient to make an informed decision. The extent of explanation required will vary depending on individual circumstances of the patient and complexity of the case. And they specifically underline of the patient. So we'll see how far this goes, because when talking to doctors, they all complain, look, I have no time to do the proper consent. And hopefully after listening to Mr. Badenoch, you all will decide that you better make time. Thank you.
Thank you very much, Philip. I'm delighted and honored to be here in this university. Not only do I come from an entirely medical family on both sides, father, grandfather, 2 great-uncles, 4 uncles and 7 cousins are all doctors or surgeons, which perhaps explains how I ended up in medical law. But I have a very strong connection with your university. My grandfather, Professor Lancelot Forster, my mother's father, was a professor at this university before the war. I've learned today, thanks to a book which Terry Kahn kindly copied to me, that my grandfather was registrar of the university and was for some years Dean of the Faculty of Arts in this university. And so for me it's a moving experience to find myself lecturing here, not exactly in the buildings that he would have known, but at least in the university of which he was so rightly proud. He, I'm afraid, ended up in Stanley Japanese prisoner of war camp for nearly 4 years, having been captured when Hong Kong was taken. But when I was a lad at his knee, I grew up on so many stories of his happy days working in this place. So that makes me very glad to be here. I'm talking this evening on the physician's duty of care and the future of Bolam. And I guess many, if not all of you know, what we mean when we mention Balaam, but I'll come to it in more detail shortly. First of all, can I check you can all hear up the back? Is it all right? You can. Good. First, do no harm was the principle long ago set down as the primary duty of a doctor. It's not a bad starting point today, though its proponent Hippocrates was a physician of ancient Greece who died in 370 BC. In philosophical terms, it can be said that the primary duty of a doctor towards his patient is twofold. Always to consider and act in the best interest of his patient, and always to put his patient's interests above his own. This latter proposition, to put his patient's interests above his own, collides sometimes in today's acquisitive society with the growing commercialization of medical practice, which has seen, among other things, a notable increase in the number of those who choose medicine because it's a good business to be in, and as is perhaps most vividly illustrated by the extraordinary proliferation of surgical practices devoted solely to cosmetic plastic surgery. Staying with this aspect of the doctor's duty of care for a moment, putting the patient's interests first, it has been suggested, and some research in the USA supports it, that the growth of the so-called defensive medicine, which is a source of concern and criticism in some quarters, is not so much a product of the excessive fear of people like me, fear of litigation, or of an overzealous desire to protect patients, but rather the result of doctors profiting from unnecessary tests done because they have a financial interest in the laboratories which report on the tests. But leaving aside that rather jaundiced view of modern-day medical practice, I turn to some basic law. I'm sorry if I'm teaching those who already know it only too well, but I think it's the right starting point before we come to the duty of care of a physician. The legal principle which imposes the standard of care expected of the general population, which is all of us, in its ordinary daily activities, is the standard of the notional reasonable man. Don't do what a reasonable man would not do, do only what a reasonable man would do. And this reasonable man, whose attitudes and behaviour provide the objective test of actionable negligence in our law, was, as some of you will know, identified by the judges in the old days as the man on the Clapham omnibus. I think sometimes now described as the man on the Northern Line, but meaning a man of ordinary sense and sensibility, neither perfectionist nor lackadaisical, whose notional behaviour would be the standard by which to judge alleged misconduct in daily affairs of ordinary people. When it comes to the question of to whom do we, as a generality of people, owe that duty of care, the law's answer is to anyone in the category of our neighbour. And neighbour was defined all those years ago by Lord Atkin as a person, any person, who is so closely and directly affected by what we're doing that we ought to have them in our contemplation when we're doing it. And any breach of that duty, the duty to act as a reasonable man towards our neighbour, any breach of it is characterised as negligence, and any harm done thereby to a neighbour attracts a legal remedy. And for society as a whole, it's always been the role of judges, when negligent harm is alleged but disputed, to rule on whether that duty was owed in the first place, and whether there was a breach of it, and if there are opposing expert opinions on that subject, the judge, hearing both, decides which opinion of the expert he prefers and which he rejects. And that's been a perfectly straightforward role of the judge for a very long time indeed. And it might be thought that that general common law duty of care and the judicial role in policing it would apply perfectly well also to the professional acts and omissions of doctors and surgeons. But things, I'm afraid, are not that simple. A problem is seen to arise in the fact that judging a doctor's or surgeon's performance by reference to the notional reasonable man is not appropriate, because Mr. Averagely Decent Citizen doesn't make diagnoses or perform operations and wouldn't have a clue how to do either well or badly. So the law applies, and has to apply, it's thought, a refined version of a duty of care to the practice of medicine, and it's expressed in a mercifully simple way the duty or obligation to exercise reasonable care and skill. This the law holds to mean the standard which is expected of an ordinarily competent doctor professing the relevant expertise, not the standard of some particular world-breaking expert or Olympian. We should note that this legal duty of care is not owed by doctors randomly or at large, but is only owed to one who stands in the relationship of patient to him, which means, and it only arises, when the doctor takes it upon himself in his professional capacity to care for or to treat. And it follows that in our law, a doctor does not owe a general duty to care for anyone who appears to be in need of medical attention. He doesn't owe the duty to go to the aid as a good Samaritan of an injured person in an accident that he witnesses. That said, if a doctor does choose to help a person knocked down by a car or, let us say, taken ill in the theatre, that person does then become in law his patient, and the doctor will owe him that duty of care. So far, nothing I'm sure would seem to you particularly contentious. But before I come to the main burden of this talk, the so-called Boland principle, I express two concerns about the doctor's duty of care in the modern age. These concerns are born in particular of my experience of catastrophic birth injury cases. The first is the creeping erosion of direct personal responsibility for the patient by the proliferation of dictatorial protocols, advisory notices, and in some instances mandatory checklists, which are said or imposed to govern the way treatments should be selected and the way they should be applied. These emanate from a variety of sources, in particular in the UK from the GMC, the General Medical Council, the Royal Colleges of the different specialities, the National Institute for Clinical Excellence, which is charmingly called NICE, and from the hierarchies in many, if not all, our hospitals. They are principally the product of concerns about the cost of clinical negligence and of a laudable desire to secure consistency of care by standardizing its delivery. But whether these protocols are intended to or not, and we all know the law of unintended consequences, they do have a tendency to remove independent thought and decision-making about the individual case and to replace it with a kind of tick-box mentality. I see this, so I must now do that. I've done that, so I must now proceed to do this, etc., ticking each box. The doctor is expected to follow a mapped-out, preordained pathway which is designed to cover a particular type of case, as if all patients were standard issue. The steps thus followed may, of course, and in some instances may not, be the right steps to meet the particular patient's actual needs at the time. But the taking of them and the ticking of the box satisfies the doctor that his duty of care is fulfilled. When there is any subsequently arising issue of whether he has properly discharged his duty, it becomes subsumed into the question, has he followed the protocol? It hardly needs me to tell you, or to say, or to point out that a step which can be perfectly correctly ticked off may not in fact be the right step, or a sufficient step for adequate care in a given case, and indeed may in some cases be the wrong step altogether. Yet, the tick in the box will have the effect of assuring the doctor that he has done enough and that he's done the right thing. My second concern, which is partly a product of the first, is the assertion frequently heard nowadays, certainly in the courts in the UK, that a medical mishap must not be attributed to any error or personal dereliction of duty of any individual doctor, but is instead rather the result of what is called system failure, of which the doctor is supposedly a hapless victim, and by which the doctor is supposedly absolved of any personal responsibility. The cry of system failure is frequently nowadays raised to excuse rather than to explain or to mitigate an individual's personal failures of care. And I think that's a subject on which on another day it would be interesting to have an entire meeting, because it's certainly in the crippled NHS of England becoming a very important topic. The doctor who says, well, I know I should have done better, but we were understaffed, under-resourced, we didn't have the right equipment, we weren't given the right facilities to do what I ought to have done. So it's not my fault, it's the system. Well, there may be something in that sometimes, of course, but it needs very careful thought before a doctor is absolved of his own direct responsibility for what, after all, is his patient. Well, to come at last to the main topic, the notorious case of Bolam against Free and Barnet Hospital Management Committee of 1957, which, excuse me, you have to forgive me a moment, which, as you know, drastically and deliberately restricted the right and the opportunity of the courts to find doctors negligent. Any discussion of the case of the so-called Bolam principle, the principle being derived from the case, must start from the recognition that the nature and the limits of a duty of care are only definitively established when we've identified what it is that will be held to constitute a breach of that duty. And the problem here, which can be seen to have led to the judgment in Bolam, is this. Doctors may prospectively differ quite legitimately about what the right diagnosis or the right treatment for a patient actually is. And it would be a harsh law indeed which held that a clinical decision which is shown only with hindsight to have been wrong, it would be a harsh law that held that to be negligent. My thesis is this: Bolam seriously overcompensates for that problem. In Holt and Hanley, a Scottish case which was in fact progenitor and precursor of Bolam, the court expressed the problem in this way. In the realm of diagnosis and treatment, there is ample scope for genuine difference of opinion, and one doctor clearly is not negligent merely because his conclusion differs from that of another professional man, nor because he has displayed less skill or knowledge than others would have shown. The true test for establishing negligence in diagnosis or treatment on the part of a doctor is whether he has been proved to be guilty of such failure as no doctor of ordinary skill would be guilty of if acting with ordinary care. Well, few would quarrel with that. A perfectly fair statement on the face of it, and one with which doctors and patients would happily agree. But then along came Bolam, and with it the regrettably influential decision given by Mr. Justice McNair to the jury in that case, which in its pure form greatly limits the circumstances in which a doctor may be held in law to have been negligent. Now, that the Bolam case was heard, a civil case for damages alleging professional negligence was heard in front of a jury, may surprise you. But in those days, all civil claims for damages in England were, as they still are in the USA today, heard before and by juries. Some years ago, I had the privilege of hearing an eloquent address at the Congress of American Trial Lawyers on techniques for the closing speech to the jury in what they call medical malpractice cases. The speaker proudly described his many techniques for enlisting the sympathy of the jury in his cases. And then he came to the crunch. At this point, he said, I usually cry. I think of my late sainted mother and the tears flow easily and most effectively for my purpose. Not a technique that I've yet tried myself in front of judges in England or Hong Kong. I emphasize, not yet. The plaintiff in the case was Mr. John Hector Bolam. Not a lot of you will have known his full name. He was very depressed before he began his medical negligence claim. That was why he was given the electroconvulsive therapy, ECT, which resulted in the injuries which led him to sue his doctors. I'm entirely certain that he was even more depressed at the end of his case, not only because he lost it, but because it gave his name to the legal principle which caused him to lose it, and which gave him an unenviable immortality in the law. In these turns out the case that bears his name has long stood as the leading case on the standard of care expected by law of the medical profession. And it has, until recently, withstood all attempts in the UK to diminish or to demolish it, where our bolder Australian cousins, by contrast, toppled it some years ago from its pedestal. And in England, the Supreme Court has, in my case of Montgomery against Lanarkshire Health Board, removed Berlam altogether from the test of the adequacy of information disclosure by doctors for the purpose of patient consent. That is for another day, that talk. In fact, I'm doing it tomorrow for the bar, as I recall. The facts of Mr. Berlam's case are seldom recited and are, I think, largely forgotten, but they repay study. Incidentally, when it comes to the facts, one of my university tutors, the great Dr. J.H.C. Morris of Dicey and Morris fame, was reputed to have given up his practice at the bar because the evidence, as given by his witnesses, and the facts, as they turned out to be, were so inconvenient and so unsuitable for the brilliant legal arguments that he'd prepared and wanted the facts to illustrate. For of course you need a very special set of facts to present themselves before you can distill from them the new legal precedent which you set out to establish. I should just pause there and say, any of you who've studied the case of Montgomery will see that it presented to me the perfect storm of facts on which to challenge the old law relating to information disclosure for consent. So those facts fitted the bill perfectly. Now, I'm going to tell you about the facts of Mr. Berlam's case. He was given his ECT, which involved the administration of electric shocks to his brain under the direction of psychiatrists. Those shocks resulted in muscular spasms so violent that he was thrown bodily to the floor, where he suffered serious fractures when he landed, and he was left permanently disabled. At the trial of his claim against the hospital for having negligently failed to prevent his fall, the use of ECT was not in question, although we all know that it has always had its vociferous opponents. What was in dispute was whether before the shocks were administered he should have been given either muscle relaxants to sedate him or have been restrained by belts or otherwise to keep him safely on the treatment table. He quite reasonably said that he should, and he called eminent psychiatrists who supported him. However, for the defense, other eminent doctors asserted, surprisingly you may think, that relaxant drugs and restraints themselves carried risk, and that there was a body of medical opinion which reasonably opposed their use and would not use them. Then came the trial judge's direction to the jury on the law that they had to apply when they were deciding whether the omission of sedation or restraints was negligent. Faced with those conflicting medical views, he directed the jury in these famous words: "A doctor is not guilty of negligence if he has acted in accordance with a practice accepted as proper by a responsible body of medical men skilled in a particular art." Putting it the other way round, a doctor is not negligent if he is acting in accordance with such a practice merely because there is a body of opinion that takes a contrary view. And much trouble seems to me to have followed. It has led to too strict adherence upon those last words. They were restated and endorsed by the famous Judge Lord Scarman in a case called Maynard against West Midlands Regional Health Authority in 1984. He summarised the Berlam principle as follows: "It is not enough to show that there is a body of competent professional opinion which considers there was a wrong decision, if there also exists a body of professional opinion equally competent which supports the decision as reasonable in the circumstances." And the final fateful words: "In the realm of diagnosis and treatment, negligence is not established by the judge preferring one respectable body of professional opinion to another." This new principle led, in my opinion, to the wrong decision in Mr. Berlam's own case. The jury dismissed his claim for negligence. It has also, I believe, been responsible in the many years since its promulgation for much similar injustice. In its purest form, it removes in medical negligence cases the function which is the judge's in all other negligence issues, that of identifying and finding actionable fault. The principle of Bolam hands that role over to the medical profession as judge in its own cause. The judge, if I remind you of what was said in Bolam and Maynard, may not simply establish negligence by preferring one lot of expert opinion and rejecting the other. In its strict application, therefore, medical defence experts have only to assert, well, I was going to say only to establish, but actually often only to assert, that some doctors, whom they would call reasonable, would do what the defendant did. And once the judge hears that, unless he thinks those on the defence side are obvious liars or charlatans, the judge must suspend his own critical faculties and is literally legally disqualified from finding negligence, even if, as the Bolam test would have it, he greatly prefers the plaintiff's expert's opinion to the defendant's. If the defendants represent a body of reasonable opinion, however small a minority, on the Bolam principle, the judge may not find negligence in that case. And the resultant injustice is exemplified by decisive evidence in many cases, in my experience, particularly in the past, from defence witnesses, not that they themselves would do it the way the doctor alleged to be negligent did it, but they knew of some doctors who would. And often in my early days in practice, this led to apparently unscrupulous but totally successful defences of the rationally indefensible. Small wonder, given those expressions of our law, that the Times newspaper headline when they reported the Hunter and Hanley case was this: "No negligence where doctors disagree." The Times could see that the principle allows the medical profession itself, one, to identify the doctor's duty of care, and two, to identify its limits, and three, therefore, to decide whether there's been a breach of the duty of care. In short, as I have said, to be judge in its own cause, a privilege which is not granted under our rule of law to any other section of society. So, my thesis is this: one, the doctor's duty of care is, by the Bolam restrictive definition of its breach, unjustifiably confined. Two, that this exceptional treatment is unacceptable in a society governed by the rule of law. And three, that the application of the normal judicial process to alleged medical negligence will not create unfairness to doctors or open the floodgates of unwarranted claims. But in this, you, the audience, will no doubt be my judge, because I am aware that my heretical views about Bolam are not shared on every side, and that there are at least a body of doctors who would strongly defend the continuation of the principle when they are alleged to have been negligent. To return to poor Mr. Bolam's case, I think most of us would find difficulty in discerning what the alleged risks from muscle relaxants or restraining belts were, and how serious the consequences would have been had they been used. Further, I think we would consider that those risks, if any discernible, paled into insignificance compared to the obvious risk of being hurled bodily off the table onto a hard floor. We might reasonably ask whether, in light of those comparative risks and benefits, any support for failure to sedate or restrain the patient, we might question whether it was either rational or logical, and indeed whether the failure was in any sense legitimately defensible. My answer is, plainly it was not defensible. Indeed, that it was so irrational as to invite skepticism as to whether it was a truly honest defence. But it was a long time ago, and I wasn't in the case, and so I haven't and never will have the opportunity of challenging those who advanced that defence on behalf of the doctors in Mr. Bolam's case. But the fact is, that was how things for a very long time stood, with frequently irrational and frequently illogical defences unashamedly advanced, because any purported professional endorsement would, by Bolam in its strictest form, suffice to exonerate the defendant. Many of you will know, I think, that the case of Bolitho, that's how it's pronounced, a colleague of mine was in the case, B-O-L-I-T-H-O. The case of Bolitho against the City and Hackney Health Authority in 1998 was widely considered to have redressed the balance somewhat. The law lords, in that case, they're now called, of course, the Supreme Court in the UK, the law lords in that case graciously allowed the judge, in what they called rare circumstances or rare cases, to resume his normal role by applying his own critical faculties to a practice supported on the Bolam basis. The law lords still ordained that breach of duty must be decided by reference to the Bolam test, but they qualified it thus. In the vast majority of cases, the fact that distinguished experts in a field were of a particular opinion will demonstrate the reasonableness of that opinion. But if, in a rare case, it can be demonstrated that the professional opinion is not capable of withstanding logical analysis, the judge is entitled to hold that the body of opinion is not reasonable or responsible. It is only where a judge can be satisfied that the body of expert opinion cannot be logically supported at all that such opinion will not provide a benchmark by reference to which the defendant's conduct falls to be assessed. That decision of the House of Lords undoubtedly went some way to moving the courts away from Bolam's excessive deference to the medical profession. And there were those who cried "Eureka" when it appeared. I was not among them. I was not among them for two reasons. Firstly, because good judges had, in my experience, been following a Bolitho-type principle for many years before that decision. If it had been otherwise, plaintiffs in all defended medical negligence actions would certainly have failed, given that by definition in such cases there were ostensibly respectable doctors on the defence side who purported to sanction what the defendant had done. It is true that in front of certain judges no such case was ever run. I name no names except Mr. Justice Ian Kennedy, where there was an impressive group who conscientiously applied their own intellect to medical disputes. And their judgments, many of them reported from these good judges, rejecting one medical expert opinion as unacceptable and illogical and preferring another, can be seen to reflect the fact that logical analysis was by those good judges applied long before Bolam was decided, at least in some courts. I should say that my other reason for lack of enthusiasm for Bolitho was that on his extremely distressing facts, the young infant plaintiff Bolitho should, if the law lords had applied their own much vaunted logical analysis to the defence case, most certainly have won. Whereas, with the appearance to me of gross injustice, and despite the pronouncement of an allegedly brave new principle, he lost it. Now trespass on your time by telling you of a case in which I was myself involved acting for the plaintiff in Cardiff in Wales some 25 years or more ago. The decision of Mr. Justice Michael Wright in that case is regrettably unreported, and I've never been able to put my hands on any version of it. The facts can be very simply but rather distressingly stated. The defendant obstetrician was carrying out a caesarean section. He had hold of the baby's feet and was lifting the baby out by its feet through the incision when the uterus suddenly went into a spasm, muscular spasm, around the baby's after-coming head and neck. So he now had the baby's head within the uterus with the muscular spasm clamped round its neck and head. And of course it was a dire emergency, as all experts on both sides agreed, because until released the baby was undoubtedly needing to breathe as if he was out, but unable to do so because he was trapped within the womb. The baby was therefore asphyxiating before the doctor's eyes and in his own hands. For this appalling predicament, the plaintiff's two expert obstetricians, men of great eminence and distinction and experience, said that there was a simple and immediate solution. This was to cut at once a second vertical incision at right angles to the initial transverse incision, which would cut through the muscle of the uterus, immediately open the womb again, and allow the baby's head to be lifted out instantly, and so instantly relieve its asphyxiation. This, they explained, would be the work of seconds, literally seconds. This seemed like perfect sense to me, and I imagine that it does to you, provided it could be done without additional risk to the safety of the mother and baby, and the plaintiff's experts asserted that that was so. They were not contradicted. They said it can be done exceedingly quickly, and it won't present danger at that time to the baby or the mother. Brain damage would thus certainly have been altogether avoided. Well, the defendants' doctors, the professors, these distinguished professors, I have to say, called by the defense, although they agreed with that, they strongly condemned the idea of the vertical cut. Before I get to their evidence, however, I should tell you what the obstetrician actually did. Remember, he's holding an asphyxiating baby by the feet in his own hands. Instead of making the cut, he chose simply to wait until the spasm should subside. He knew that at some point it would, though he had no means at all of knowing how long it would take. So he waited, and he waited, and tragically, by the time eventually that spasm relaxed, the baby had suffered catastrophic asphyxial brain damage. But the case was defended throughout by lawyers who argued that the decision to wait was a legitimate obstetric choice, a reasonable course to take, and one supported by a body of medical opinion which would support and endorse it. Those two professors for the defense, professors of obstetrics, were from the famous Guy's Hospital. I pause to observe that professorship is not always or necessarily, in my experience, a reliable indicator of either wisdom or practical experience. Those professors cited a passage from an old textbook, of which I had sort of vaguely heard. I emphasize an old textbook. It was called McGillivray. In that textbook, the T-shaped incision which would result from the second vertical cut was called, quotes, an unacceptable mutilation of the mother's uterus, which would, said the text, threaten the mother's future fertility. I am sure you will note, as I did, this touching concern for her future fertility. With this text, both professors claimed to agree, and they insisted that the T-shaped incision should never be countenanced, and that they would not have done it. It was to them quite acceptable for this obstetrician simply to wait until, whenever it might be, that the spasm would relax while the baby was in the meantime asphyxiating. And there, said defending counsel, you have a cast iron Bolam defense. And pausing there for a moment, indeed, the defendant did have a cast iron Bolam defense. I lost the case, and in his judgment, the trial judge emphasized that two eminent men had criticized the vertical cut and that they were supported by published learning. He recited and relied upon those passages from Bolam and Hunter and Hanley and Maynard, which I read out just a few minutes ago. He found not only that the obstetrician's inaction was sanctioned by expert opinion, and that the vertical incision was unjustifiable, according to the textbook, and finally, that therefore Bolam provided a complete defense. I had, as you might say, been totally Bolammed. I pause there to ask whether you have begun to have doubts about the rationality or justification of the Bolam principle thus exemplified. Do you share my dismay and astonishment that a theoretical obstacle to a theoretical future pregnancy could possibly amount to a valid defense of failure to do something so simple which would have instantly saved the life of an actual living baby from mortal danger? The vertical incision might have represented a so-called mutilation. It might possibly have jeopardized the future fertility of the mother. But it should, on all humane and rational bases, have been made immediately to deliver this perfectly healthy infant safely into his mother's arms. Not to make it clearly defied logical analysis. And the dear mother, of course, said to me, and to the judge, with incontrovertible logic, that she would gladly have risked and even sacrificed her future fertility for the salvation of that living infant, the current fruit of her womb. That was my argument, and I suspect it would also have been yours. But because of Balaam, it failed. I was younger then, and the principles on which the judge relied were in those days still deeply entrenched in the minds of lawyers. Nevertheless, I strongly believe now that I should have appealed the decision and argued then that judges must subject conflicting medical opinions to an objectively critical eye and to independent reasoning, and that if they had done so in this case, it must have resulted in rejection of the defense experts' allegedly respectable views. Had I done so, it would, I think, have led to a Belitho-type decision long before Belitho itself came along, because these facts were tailor-made, the perfect storm for it, weren't they? I clearly missed a golden opportunity, though I suppose it's conceivable, since this was so long ago, that my appeal on this child's behalf might have been met by the conventional and strict interpretation of the Balaam test, which had undone me at first instance at the trial. I wonder what you think. I dare to hope that you agree with me that the decision was obviously wrong, indeed, frankly, outrageous, as in fact I've had the opportunity more than once to tell Mr. Justice Michael Wright to his face. It exemplified the harm of rigid adherence to Balaam and illustrates how Balaam fails to meet the essential requirements of fairness and justice and common sense. Those requirements cannot reliably be met if medical professionals are allowed the unique privilege of setting their own standard of care and deciding what constitutes its breach, which is what was happening in that case. That privilege made it possible in that Cardiff case, by the agency of a pair of shameless professors and a venerable textbook, to be judges in their own cause. How in our modern age can this be tolerated any longer? I called it a unique privilege because although Balaam and its test has had lip service paid to it in other fields of complex specialist skill, it has not been allowed generally to overbear or to restrict the normal judicial function in any field except medicine. Examples where judges apply their intellectual faculties and always have without restriction would include obviously the construction of bridges or buildings, the design, installation and workings of machinery in factories, and even in one case of mine, the formulation and manufacture of radioactive treatment heads for radiotherapy machines in hospitals. About that case I shall have to tell you the story on another occasion. It was an extraordinary experience for me. In all these cases, the judges are expected and are provably able, I have to add, to master the complexities, to weigh up and decide between diametrically opposing expert arguments and reach a fair and just decision as to which should be preferred. It's very rarely suggested that judges are unequal to this task, or that the task should be removed from them. And nothing, so it seems to me, has ever legitimized taking the task away from judges in medical cases. That other professionals don't enjoy this same privilege is shown by a number of cases. In particular, I dwell on one from Hong Kong, the well-known case of Edward Wong Finance against Johnson, Stokes and Master in 1984. The defendant solicitors followed a widely used conveyancing procedure which failed to provide adequate protection to the client from fraudulent misappropriation of the client monies. The evidence showed that their procedures, as used, precisely matched those followed by virtually all other solicitors in Hong Kong. Not good enough, said the court. They condemned the practice as negligent because it allowed this obvious scope for fraud, and they dismissed the fact as any kind of defence that it was approved by almost all the other solicitors in Hong Kong. A similar decision in an old medical case which is worth study, which was rescued by counsel in Belitho from its virtual oblivion, was Hucks against Cole, H-U-C-K-S v. Cole, C-O-L-E, in 1968. In this case, Lord Justice Sachs, ahead of his time, condemned as negligent a medical practice which was widely approved by the profession at the time, but which clearly, unreasonably, and avoidably exposed patients to grave danger. The practice was the avoidance of the use of antibiotics in cases of severe infection. His words may be familiar to you, some of you. He said this: when the evidence shows that a lacuna, that's a gap, in professional practice exists by which risks of grave danger are knowingly taken, then, however small those risks, the courts must anxiously examine that lacuna, particularly if the risks can be easily and inexpensively avoided. If the court finds on an analysis of the reasons given for not taking those precautions that in the light of current professional knowledge there is no proper basis for the lacuna, and that it is definitely not reasonable that those risks should have been taken, its function is to state that fact, and where necessary to state that it constitutes negligence. In such a case, the practice will no doubt thereafter be altered to the benefit of the patients. And in respect of the doctor's failure to use antibiotics, which his defence witnesses says, well, quite a lot of us don't approve of these modern drugs called antibiotics. the judge said this: failure to do this was not merely wrong, but clearly unreasonable. Now, if only I'd known about Hucks and Cole when I did that Cardiff case. I didn't, and it was only rescued from oblivion. It hadn't been reported. It was an unreported case by counsel in Belitho. I should tell you about Lord Justice Sachs. Lord Justice Sachs was the son-in-law of the then Lord Chief Justice, Lord Goddard. And when he was appointed a High Court judge, a wag wrote to the newspaper and said he was pleased to see that the Lord Chief Justice's son-in-law had been made a High Court judge, and it was to be hoped that the fact that his other son-in-law was a dentist would not prove a bar to his judicial preferment. The restatement of the law by Lord Justice Sachs in that way was, unfortunately, premature, and as I say, it sank without trace for years. But it did seek, in those words, to restore to the judge his proper function, the detection of flawed reasoning, the castigation of unnecessary risk in practices which medical witnesses may still countenance and even improve. But of course, that finding of Sachs lags far behind the long-standing rejection of the supremacy of Bolam in the courts of Australia. Consider the words of Chief Justice King in the Australian case of F for Freddie v. R, 1983. Professions may adopt unreasonable practices. He was talking in this case about disclosure for consent, but the remark is of general application. Professions may adopt unreasonable practices, particularly as to disclosure, not because they serve the best interests of the client, but because they protect the interests or convenience of members of the profession. The court has an obligation to scrutinize professional practices to ensure that they accord with the standard of reasonableness imposed by law. Now, nobody can really quarrel with that proposition. Our law is what imposes standards of behaviour upon us. We are governed by the rule of law, and I know that in Hong Kong at the moment there are nervous feelings that it's under threat. In Darley and Shale, Darley against Shale, in 1993, another Australian case, the Australian judge, Mr. Justice Woods, said this: while a failure of a defendant who pursues a particular occupation or profession to act in accordance with the current standards and practices of that occupation or profession will amount to a breach of the duty of care, failure to act in accordance with the standards of your profession, the converse does not necessarily follow. Evidence of current practice is almost always of great value, and it may be decisive. Yet, when explored, it may nevertheless turn out to be negligent practice. It is in this respect that the Bolam test may be unhelpful or inappropriate as a single determinant of general application. I agree with him wholeheartedly. The defence arguments that this is acceptable to a body of medical opinion may be of the greatest relevance to the judge's consideration, and indeed they may be decisive of a given case, but they must not be the ultimate determinant of whether or not negligence is proved. But that is what Bolam does. So what's happening to Bolam? The answer is that it's undermined, if not yet dealt a death blow, by the proper application of that Belytho principle, judges applying logical analysis to see if the defence case stands up to it. It's also under threat, of course, the Bolam principle, by the obvious decline in the excessive, as I would call it, deference to the medical profession which has historically been shown, and also by the inexorable march of evidence-based medicine, which admits of proven right and proven wrong in grey areas of medical practice. But there are other influences at work. In the so-called informed consent to treatment cases, there were a significant number of English decisions where failure to warn a patient of a relatively small risk, but nevertheless of very serious harm, was endorsed by many doctors, and yet was found negligent by the courts. The concept of a requirement to inform the patient of any risks of treatment to which a reasonable patient might be expected to consider, relevant to his decision whether to consent, has long since been entrenched in all European law and all North American law. But it took the decision of the Supreme Court in England in Montgomery in 2015 to establish it in our law. And it's a nail, undoubtedly, in Bolam's coffin, because what they said is Bolam has no place at all in the judge's consideration of whether the amount of information given to the patient for the purpose of his consent was adequate or not. What they said was, the test is not the professional sanction or endorsement of a body of medical opinion. The test is only and simply the reasonable patient test. Was what was disclosed sufficient to meet what would be the requirements of information of a reasonable patient in the particular circumstances? Did the doctor give the patient the information that a reasonable patient would want and need to know? And some of you will very well know how Montgomery had a wonderful example before it in Australia of the circumstances in which disclosure in Australia was held not to be the subject of Bolam defences. The case was Rogers and Whittaker, and in that case a woman who was blind in one eye, had reached middle years, had raised her family and was returning to her profession of teaching. She didn't like the cosmetic appearance of her blind eye, and she went to a surgeon and asked whether he could improve its appearance. The blind eye, remember. He told her that he could. She asked, in fact, directly whether there were risks, and he replied no. He told her of no risks at all. There was, in fact, sadly, one particular risk, a very small one. It was a risk about 1 in 20,000 or so of what is called sympathetic ophthalmia, which is to say the risk that when you operate on the blind eye, you may destroy the sight of the good eye. She went ahead without any knowledge of the risk, tiny though it was. You've guessed it, of course. When the operation took place, it blinded her good eye and she was rendered entirely blind for the rest of her life. She sued the doctor for not having disclosed this risk. And I may tell you that surgeon after surgeon appeared for the defence, called by the defence organisations, to say they wouldn't dream of telling a patient of a risk so small. That was a cast iron Bolan defence. And the Australian judges said, nonsense. In this particular case, the endorsement, sanction or approval of any number of medical professionals had nothing to do with it. The issue should be turned right around, and the only question that mattered was this patient, as a reasonable person, given the sort of information which she would reasonably be entitled to expect? And they answered no. And they dismissed Bolan from that consideration. And that was a long time before we ever got to that point in English law in the Supreme Court in Montgomery. And if I've got just a very few minutes, I'll just tell you quickly the facts in Montgomery. Mrs. Montgomery was about 5 foot tall. In England that means she's a very small person, and even here I think so too. She was an insulin-dependent diabetic, which meant that because of certain features of diabetes, her fetus was growing abnormally large. It is known to do that in insulin-dependent diabetic mothers for reasons I'm not sure I could ever understand. And another unhappy feature of such babies in diabetic mothers is they lay down excessive deposits of fat upon their shoulders. So they end up oddly very big and with huge shoulders, much bigger than normal. And there is a particular risk attaching to that, which is called shoulder dystocia. Sometimes if that mother labours normally, the head comes out and the shoulder becomes stuck behind the symphysis pubis, and it's a dire emergency to get that baby out. She was terrified. She wanted a cesarean section. She asked more than once whether she would be able to push this baby out normally. The doctor told her nothing of the risk, even though about 10%, 9 or 10% of labouring mothers with this condition and big babies end up with shoulder dystocia. And even though of that 10%, 1 or 2% will come to terrible grief because it's so difficult sometimes to get the baby out that they suffer asphyxial brain damage and even die. The doctor told her nothing. The doctor even reassured her, as the doctor put it in evidence, that if anything went wrong in labour, they would go to caesarean section. You can't go to caesarean section if there's been shoulder dystocia because the head's already out. Although there is something rather odd called the Zaffanelli manoeuvre, which in third world countries involves pushing that baby right back up into the room in order to cut it open and remove the baby. But that is not something countenanced in the civilized world. The doctor told her nothing, measured that baby by serial ultrasounds every fortnight, which is very unusual in pregnancy because they knew it was getting bigger and bigger. They did see that it was getting bigger and bigger. In the end it weighed over 9.5 pounds, as I recall. They told her nothing. They imposed labour upon her by inducing labour. When labour got predictably obstructed and stuck halfway down, they didn't go to section at that point. They pumped her full of syntocinon to augment the uterine contractions and force the baby out via the vagina. The baby's head came out, the shoulder stuck. Dire emergency, all the room filled with all the experts. They couldn't get the shoulder free. The obstetrician, the female, she was a female obstetrician, tried to do what they do in the third world where you can't do caesarean sections. She took a device and tried to saw through the mother's symphysis pubis. She hadn't got the right kit, so she only got halfway through and had to give up. She then put the forceps on, and as she described it, with superhuman effort, she pulled the baby out. That case was defended throughout. They defended on the basis it was perfectly all right to tell her nothing about the risk. They defended on the basis it was perfectly all right not to answer her questions when she asked, will I be able to pull it out truthfully. They defended on the basis that it was perfectly reasonable not to offer her elective caesarean section. They defended on the basis that it was perfectly all right not to go to caesarean section when it got stuck. Altogether, the thing was indefensible, but was defended across the board on every front. When I tell you that the mother said, obviously, I was desperate for a section, and her own obstetrician, the guilty one, agreed she was, and said, I didn't offer it to her because I don't consider caesarean section to be in the maternal interest. The plaintiff's own experts said if offered, all obstetricians of course, said if offered as a section, of course she would have taken it. Mothers always do when they're 5 foot tall with an enormous baby. The defence experts both said that if she'd been offered it, of course she would have accepted it. The defence counsel argued that if offered it, she'd have refused it. the trial judge said, quite right, if evidence she'd have refused it. And the 3 Scottish appeal judges said, what a sensible decision, how right they are, if offered it, she'd have refused it. And they all agreed in Scotland, the first judge and the 3 appeal court judges, that this was entirely defensible on the Bolam principle, because the defence doctor said, well, we wouldn't tell about this tiny risk. Claim dismissed, said the trial judge. Quite right, said the 3 appeal court judges. Claim dismissed, not a chance, absolutely Bolam all the way. Supreme Court in London reversed all those findings of fact, something which an appeal court almost never does, because they don't hear the witnesses. They reversed the findings of fact. They ruled effectively that there was no defence at all to this case. And they ruled also that Bolam had no place whatsoever in the disclosure of information for the purpose of patient consent. I've gone on an awful long time. You can tell I feel quite strongly about this. I am not an enemy or torturer of doctors. I come from an entirely medical family. Let me just tell you this. I repeat, with Bolam gone, all that is removed is the principle that it is simply enough to disqualify the judge from making his normal rulings to produce a body allegedly of doctors who would approve or sanction what was done or not done. That won't do any more, is what I say. The expert opinion for the defence will be crucial in some cases and definitive in many, but what it should not be is by itself, of itself, decisive of the answer. Could I just conclude by reading to you some prophetic words from Lord Justice Jackson in his Peter Taylor Memorial Lecture given in April 2015, after Montgomery had come out. He said this: in the latter part of the 20th century, many claimants had their guns trained on Bolam. My impression during 25 years' practice at the bar, until 1998, was that although everyone paid lip service to Bolam, it became steadily more difficult to persuade judges that errors made by professional people were non-negligent mistakes. The one exception was the medical profession, where the full majesty of Bolam continued to hold sway. But even that stronghold of Bolam was coming under attack. In Sidaway against the Board of Governors of Bethlehem Royal Hospital 1985, a case concerning the doctor's duty to advise, the Bolam test said Jackson only survived by a 3-2 majority. Actually, I think it was 4-1 in favour of Bolam, but that's neither here nor there. Finally, said Jackson, just a month ago the invaders captured the Citadel. In Montgomery against Lanarkshire Health Board, the Supreme Court held that the majority in Sidaway was wrong. The Bolam test did not determine the extent of the doctor's duty to advise. To this, Lord Justice Jackson added, under the heading Future Battles, now that the invaders have broken through the castle walls, they will not stop there. I predict that over the coming years there will be continuous onslaught on Bolam. The argument will be that the principles of tortious liability should apply to the professions in the same way that they apply to everyone else. There is no reason for the courts to accord special protection to the professions. Whether any of these attacks will succeed, I do not know, and it would be wrong for me as a judge to predict. I merely state where I foresee the next battles being fought. Some of you are lawyers, some of you are aspirant lawyers. Take up the battle. It'll be won in the end. Thank you.
Thank you. Now, I'm sure you will kill me if I were to say, time's up, let's all go home. We'll allow a few questions, and I beg Mr. Badenoch's indulgence on the timing. So, any questions? You all want to go home?
Perhaps the sound we all agree so wholeheartedly. So you won't challenge the point of view that I've expressed.
Can I ask a side question? There's So I do a lot of personal injury cases, not so much medical negligence, and every now and then we have a single joint expert. And what you've been saying time and time again tonight is that with our adversarial system. Inherent in it is a wish on the part of doctors instructed to advocate, essentially, for one side. That's what's happening, because you're saying that the judge is faced with an argument which really defies logic. On occasion.
Not always.
Sometimes.
Sometimes.
So is there something wrong with the system, and do you think that perhaps changes in the way the system is structured, so for instance by the court or the parties just engaging a single joint expert, even in a medical negligence case, would be perhaps a way forward?
Could I just say this? You're quite right that in the adversarial system, almost inevitably, the doctors are taking sides. They wouldn't have written the opinion they did, or wouldn't be called to express the opinion they did, if it were not favourable to the party calling them. Technically, in England now, under the Wolf rules, the expert is not enthralled to either party, but is an expert advising the court. Life isn't really like that, of course. And I remember Lord Clark, who sometimes sits out here in the Court of Final Appeal, saying that in an ideal world he thought experts would be enlisted without being told on which side they were being asked to give their opinion. And wouldn't that be lovely? It would be very interesting too, wouldn't it? So there is that difficulty. They are in a sense partisan. They can't help it. And in a sense, if they weren't, they wouldn't be being called in a dispute. The other point you make, which is about the single joint expert, it's a position which greatly troubles me in any complex or important case for this reason. If you have a single joint expert, you're almost imposing arbitration by an expert. And at the moment, until we abandon the idea of the adversarial system, that's a tricky concept.
Just one thing, I'd say that the advocates for either side should be there examining the expert. And what happens often in the UK is that the parties instruct experts behind the scene who don't appear in court, whose reports aren't produced, in order to advise them how to examine the expert. So to a degree, yes, it's almost a decision by an expert, but we still get the chance to cross-examine.
Cross-examine, yeah. I don't think there's any answer. Australia invented this thing called hot tubbing, where all the experts on both sides give evidence together at the same time. I'm not sure whether you have to go in the dock or something, only in the dock. And the judge just fires questions at them and watches the way they pick up an answer. And in Australia they claim it's very effective, and they've started pilot schemes in the UK. This is supposed to avoid that kind of obvious partisan confrontation. And maybe it works. I haven't got experience of it yet.
That reminds me almost like watching gladiators fight in the Colosseum and see who survives and walks out.
Yes, well, it does sound a bit like that.
Any other questions? You are all either very shy or very hungry or both. Oh, sorry. Let me pass it all the way then. I'm sure my students travel microphones very quickly.
Well, the Montgomery case touched upon the informed consent cases, and for those cases related to the surgical or treatment malpractice, can I say for those cases, Bolam test is still to a certain extent applicable?
Oh yes, very much so. They only removed Bolam from disclosure for consent. They left diagnosis and treatment in the hands of Bolam, albeit, as I've said, somewhat modified or qualified by the Belitho proviso. So it's still there, it's still fully operational. Is that what you meant? It's only in disclosure for consent they've removed it.
I would like to ask, in the medical practice, even every diagnosis and treatment will based on informed consent of the patient. And in some cases that you mentioned, we need to inform the patient even very small risk of very grave consequences because of the Montgomery.
Yeah.
So For example, in a very simple consultation, we start a medication for a patient. The risk in some cases, even though it may be very rarely happen, say as you speak in example, say 1 in 20,000 cases, 1 in 20,000 chance of very severe consequences.
Like a stroke, for example, or something.
Yes. Then it will take consultation to be, say, lengthened or not. Say maybe from 5 minutes from 10 minutes to 20 minutes to cover all those very rare adverse effect or side effect or interaction. All those, if you want to, if we doctor are required to mention all those to a patient in a consultation, then it will be not reasonable and realistic. In Tottenham, we are talking about what a reasonable man will do and practice his skill. And that seems not quite making up the story of reasonableness.
Well, the decision in Montgomery is certainly not to the fact that you have to rule out all those tiny risks that come in the packet of aspirin when you open it up. The whole burden and strength of Montgomery is the reasonable patient test. There is absolutely no suggestion that you should run through all those minute and absurdly rare risks. You have to consider what would a reasonable patient want and need to know. And that's vitally important. It was stressed over and over again in Montgomery. It is not the case that every tiny, ridiculously rare risk has to be gone into. You do have to make a careful thought about what a reasonable patient in this particular circumstance would want or need to know. So that, for example, you're going to undergo an anaesthetic, I suppose there are some who say, well, there is a very small percentage of people who die simply because they've had an anaesthetic, which I believe is true. There is an incidence of death under anaesthetic. I don't think Montgomery would require you to tell every patient going anaesthetic, you might die. So its reasonableness is the key. Very important to remember. But if, for example, it was a concert pianist and we were operating on Dupuytren's contracture or something, and you said to him there is a risk that it will make things much worse, even if it's only 1 in 20,000. If his fingers were what he needed for his job, you'd have to say, well, this patient would need to know that. But most patients would not.
Excuse something.
Sorry.
You pass the microphone back.
Go on the mic here. I'll pass the mic to you.
Sorry, Mr. Badenoch, it's on the point in related. One of the things that is often argued in Hong Kong is that if something has gone wrong at an operation, it is known risk, that negates liability. Now, I like to stand that argument on its head and say, if something is a known risk and it has gone wrong, it should put a higher onus on the doctor to avoid that known risk. Would you agree with that, or?
Yes, I think in principle that's right. Let me just take my case of Birch. The lady had some rather strange visual disturbances in her eye turning inwards. She was a diabetic and she'd had vascular compromise of the blood vessels to the muscles of her eye before, and so the overwhelming likelihood was that she had another diabetic vascular problem this time. And she unfortunately fell among the surgeons at the neurosurgical hospital, neurology and neurosurgical hospital. She was meant to be with the neurologist, but she ended up under the surgeons. But they decided they wanted to map out properly the blood vessels and the intricacies inside her head in case they were to find an aneurysm, and they gave her a catheter angiogram. That catheter angiogram carries a small risk of stroke. The particular case was one where that risk was well known, albeit small. She was also known to be a diabetic, and some doctors think they're more particularly prone to stroke in these circumstances. There was another form of angiogram they could do, which was the non-invasive MRI angiogram using contrast medium injected rather than the catheter passed up from her groin up into, I think it was right up into the head. And they didn't offer her the alternative, they didn't describe it, and they didn't take that entirely safe alternative. So there was a very small known risk, a way of avoiding it, There was no use them saying, well, this was one of those complications that can happen without fault. What the judge said in that case was they could have avoided that risk completely, and since they could have, they should have, and therefore liability was found. So you're right, the fact that it was a known complication doesn't necessarily excuse the doctor. It may do, because there are many instances where surgery and other treatment carries unavoidable risks which have to be taken in the interests of the patient. But you're right, it is not an automatic conclusion that simply because it was a known complication it's nobody's fault.
The case that you cited about in Cardiff, the obstetrician not making the vertical incision.
Yeah.
Now, supposing he had made that incision and still not been fortunate enough to save the child, then he would have been accused that you didn't save the child and you jeopardized any future pregnancy. Then what would have been the judgment? And again, would it not have come down to a body of reasonable or reasonable professional judgment that would come to his rescue? I mean, who would then protect that obstetrician?
I have no difficulty with being a judge in that case. You take the balance of risks versus benefit. The risk was of a baby asphyxiating into catastrophic brain damage or death. You're comparing that risk instantly occurring in front of your eyes with possibly damaging the mother's uterus or future fertility. If you weigh up those risks in the balance, the defense would be cast iron. I cut the vertical cut because on the balance of those risks it was obviously the right thing to do. In those circumstances, a judge applying logical analysis, which they specifically say having regard to the comparative risks and benefits, would have, in my opinion, no difficulty in exonerating the doctor, even if by the time the baby came out it was in fact brain damaged. It wouldn't have been because the case for the claimant, what plaintiff was, you cut it instantly. If it was brain damage, it would be nothing to do with the doctor's fault if it came out instantly but was still brain damaged. I may sound a bit dogmatic, but I have no difficulty whatsoever in making a ruling in that case.
I'm not convinced.
You're not convinced.
Say why? Say why?
Because there are many instances here, I'm not an obstetrician so I can't be an excuse, but there are many instances when you may take a decision thinking that's the best decision,
Yes.
but in retrospect, or later it doesn't turn out to be the way you want it.
Well, of course.
Then I don't know whether your defense is left high and dry.
Certainly not. You may have heard me say earlier on that the problem which the law has to address fairly is that a decision made prospectively, which is among those which are perfectly acceptable, may retrospectively be shown by the outcome to have been the wrong one. The law does not hold that negligent, and that is why Bolam is wrong, but the principle that the judge listens to the respectable body of opinion for the defence is right.
Okay, on that very challenging thought, I was just tempted to say that if during war someone was injured and you have a choice of chopping off his legs and saving his life or not, and let him die, what would you do? You chop off his legs. Anyway, for those of you who would like more, I'm aware that Mr. Badenoch is giving another lecture tomorrow evening in the High Court, and so find out where it is, what time it is, and get there. All right, could I please invite everyone again to thank Mr. James Badenoch.